Hi and hello everyone. Today I'm going to present my topic. My topic is an recent development of alternative dispute resolutions. First, we're going to the introduction part. Alternative dispute resolution is a system. There is an indicate an optional legal mechanism for solving the dispute outside the court. It is one of the most growing and developing industries in legal sector. It deals with another one point. Apart from going to the court for minor issues, disputes which arise out of the transaction um, or relationship can be solved in the simple, straight, and time-saving way with the help of ADR. It deals with the matters relating to the family, commercial, contract, negligence, partnership, and public disputes. The ADR means Alternative Dispute Resolution Act. Its main scope to solve the problem without going the court. Before the court, we finishing the matters in tribunals. Next, we move on to the definition part. Alternative dispute resolution is a process by which disputes between the parties get resolved or set an amicable resolutions without the intervention of the judicial institutions. Next, we move on to the concept of alternative dispute resolutions. ADR can use to settle an various of issue including civil, criminal, commercial, family and industrial disputes. Where the parties do not want to resolve their disputes, the courts yet want to settle it. ADR may help them in the resolving their disputes and finding a solution. It helps the individuals or the groups in solving the disputes while maintaining the law and order with each other cooperatives. ADR is also including in the fundamental rights under the Article 14 and Article 21, which deals particularly with equality before the law and rights to them life and liberty respectively. Article 39 of Constitution provides the provision of legal aid of poor peoples. Um, Article next we going to see what is the main scope and what we going to see uh, in next slide. It is a development. What are the recent developments? The slide comes. The area has been helpful so many parties to resolve their disputes with the help of third party with the help of various means of area. Due to the pandemic from the last year, the court system has made a big results in its process of hearing. The results has been beneficial and helpful for so many, but also not much beneficial for some. Area saves the time, money, mental, and physical disturbance which usually happens during the court matters. Area has been a big time saved for all the parties as well as to the legal system, as it helps the parties resolve, provides them resolve without going the court. um, these are the recent developments. ADR saves the time, money, mental and physical problem usually we happen during the court. This is a main scope to ADR develop the next stage. Next we go on to the virtual area. The virtual area provides has hassle-free resolves to the parties, and this does not required any parties or attorney to travel one place to another place. Both parties can communicate with each other through the video conference, which allows them both to hear and see each other. In the case of mediation, the mediator can easily communicate with the parties separately using an easy method and can come to agreemental settlement. Just like a new alternative face many challenges, white ADR will also face some troubleshootable starting them, but certain stage great and great decisions. ADR is now alternative platform for disputes resolves, but it has become the first way to resolve the disputes in a speed, fast, and effective ways. However, it should be noted that the ADR it has still free and one of the money and time saving mechanism is also some abstract before adequately security protocols must be implemented to ensure that certain data is not compromised or tampered with in any ways. So it is one of the hard tasks to provide the internet connection in the court of the same problem in whole India. Network problem is one of the most important problem. So next we move on to the impacts of COVID-19 on the resolves alternative dispute resolves. In the present circumstances with the separate of coronavirus has put everything on the hold, important to address it is an impact on ADR. COVID-19 has caused havoc on the global economic and corporate relationship, causing unprecedented distributions. A large number of commercial beneficiaries are arising as parties struggle to fulfill their contractual obligations. Hence, because of this pandemic, virtual hearing ADR has come into existence. Um, these are the main impacts in COVID-19. Um, Delaying the resolutions, pending the court cases. These are the many problems facing in COVID times. They cannot frequently court can uh, court also cannot run. So automatically alternative dispute resolutions tribunals also could not do anything. So next we move on to the amendment of 2021. This amendment, one of the recent amendment in arbitrations and consolidated act 1996, the arbitration and conciliations amendment act 2021 has been amended in 6 years legislative intent to amend the act 1966 through major rules. This amendment has made two major changes. First, it allows the automatic say on awards in some cases where the court has prima facie evidence that a contract on which the awards is based was tendered by the fraud and corruption. The major changes in the Act of 1996 is omission of 8th schedule from the main act. It specifies the qualification, experience, regulations, and norms that should be followed from accurate mediations of arbitrations. These two um, main and major changes in the Act of 2021. Next, we move on to the 2021 amendment effects on the Indian arbitrations. The impact of automatic stay on awards. The amendments made in section 34 of the main act is most substantial changes done to the provisions of arbitration awards in the Amendment Act of 2021. In the main states in the section 34, it has been started that a party can file an application before the court for setting the arbitration awards aside. Mm, Next, we see it has an retrospective effects which will be deemed to effectively affected from October 23, 2030. Next, we see in Parliament the complaint or unconditional stay say has been criticized so many times during the introduction of bill in the Lok Sabha. Next, we see that if will automatically creates an ambiguous situations where the defense parties may suffer the rights procedure of litigations even if the party is right, and it will also open the gate of court for high waves of litigation by overburden burdening the court system. In Parliament, in first of all, engaged in the Lok Sabha, they have unconditional say criticisms there. So after that, these are the main effects in 2021 amendment. Explain the scope and qualification of arbitration. First of all, we see this area includes two amendments, including the amendment of 2019, which is interlinked with the amendment of 2021. The amendment made in the original or main act that added section 43J started the qualification, eligibility, and norms for accreditation. After the professional level qualification, they said schedule also provides the general norms which could apply the arbitration for reasoning, accuracy, as said, integrating fairness, being an imperial neural, etc. This qualification and the general norms were bordered this section among the order things limited the qualified foreign lawyers' ability for acting as an arbitrator within India. The Lok Sabha appreciated the bill by standing that it will be attached limited arbitration from foreign countries and will also added to making the India and global harms in international arbitrations. Next, we move on to the view on justice Chandrachud dissensions of justice. The Honorable Justice Chandrans have mentioned in one of the events organization organized on online disputes hearing have made a great impact on justice system in last year virtual hearing. They have made the process even more effective due to the various simple changes in the process, such as and digital to all the parties digital notes having the file to the parties. Next, we move on to the emergency arbitrations. The concept of emergency arbitrations provides emergency arbitrations who can be utilized when urgent relief is needed, and during the period of the pandemic people use these provisions. The said issue against came into the lead during the yearly wide disclosed dispute in Future Reliance versus Amazon, where the parties are Amazon, Future Groups, and Reliance. The court, after observing the issue, the validity of order award is given by the EA, gives it is a decision in favor is reorganizing emergency arbitrations as legitimate arbitrated under the Indian law. Finally, we going to the conclude part. Conclusion. ADR is one of the most important legal institution that will be succeed greatly in the future as the time changes in the forms and mechanism are also developed in the different way to resolve the disputes and make it easier for the parties for the disputes. Different emergency provisions improves area helps to improve for their facts. The new amendments have been provides a broad board framework and exposed to the mechanism of ADR so that the process can be take place effectively upcoming days. So this is my topic. Finally, I am going to conclude my topic. These are the recent developments